Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers and the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. I have with me today Kristen Gross, who does estate planning. And I thought it would be a really great time to talk about when is it important to have a financial power of attorney and the health directive? And can you talk a little bit about both of those things?
Certainly.
And I guess divorce related, but we can just talk in general too.
Sure, Carri. And thanks for having me talk about something that's really, really important to me, but important to the your Michigan listeners as well. If you have folks who live outside of the state of Michigan, I'm not licensed there. There are documents, though, that are very similar to what we have in Michigan. They might be called different names and they may have certain unique provisions. So I'll just give that general disclaimer that whatever I advise you about is going to be based upon Michigan law. In terms of a general durable power of attorney, which otherwise known as a financial power of attorney, is a document that would govern general financial matters and other things. One would implement something like that after they become an adult. So after the age of 18, your parents can no longer make decisions for you. And so it's really important to start thinking about whom you'd want to serve as the decision makers in the event that you are either unable, because maybe you're out of town, or you're sick, you're incapacitated. So there's two different criteria in Michigan under which you could have that document effectuate. Some people are more comfortable having the document only effective during incapacity. And the criteria under the documents that I draft typically require that two doctors make that determination before the person that you designate, that person is called your agent, could step up and start making decisions. Those decisions can govern things like bill payment, filing your taxes, closing on a house, signing mortgage, loan documents. Also other things like hiring a caregiver to take care of you or clean your house, buying you clothes, taking care of your pets, or in the document that I draft, if a client has minor children, I actually also put a provision to nominate guardians for your children who it might just be a temporary guardianship appointment, because hopefully that incapacity may only be a temporary one. So if you don't have these documents in place and you become incapacitated, and this includes a spouse in terms of an ability to act, there is no ability for someone to make decisions for you. So it would require, if you are incapacitated, an interested person to petition the court in the county where you live to be appointed as conservator. And that's the name of the person that gets designated.
Right, so let's give an example for a second.
Sure.
So you have an adult, 18 years old or older, doesn't matter if you have parents, if you're married or whatnot.
Correct.
And you get in a car accident and you're in the hospital.
Mm-hmm.
So if you don't have this, what happens?
So if we're talking about the general durable power of attorney, not the healthcare yet, because that's a whole other document, a whole other set of, criteria. But if you don't have this and someone needs to pay your bills, your rent or the mortgage on your house, or get money from your bank account, in order to take care of you, they cannot. So it would require whoever those people are, and really it's whoever files the petition with the court. So it could be your sibling whom you would never want, in 100 years to have control over your checkbook. But that could be the person who shows up at the court and says, I'm the person who wants to serve as the money manager / conservator. And if no one objects, that person will likely be appointed. And at that point, you're in the hospital, you don't have a voice. You're not able to come forward and say, this is my sibling who's completely irresponsible. I would never want them to serve. So this person steps into your shoes and becomes your voice, but it may not be the best suited.
That makes sense. And then if someone wanted, and if you're like a parent and you're going to the hospital and you're like, this is my kid, I want information, and the kid's 18 or older, they're like, can't give it to you.
That's correct. So in that area, we're stepping into what's called a healthcare power of attorney or patient advocate designation in concert with a HIPAA authorization. Those are the two documents that would assist you in the circumstance where you show up at the hospital and you say, I want information. Well, if you don't have an authorization, a release signed by the patient, the person in the hospital, then you are in all likelihood not going to be able to receive information. Now, in some settings, hospitals will release information if you're the parent or the spouse, but legally, they're really not permitted to. The hospital walks a fine line when they do that, because if they release information and then they later on find out that this was a person whom the patient did not want to receive information, then they could get themselves into a lot of trouble. So sometimes they'll talk to you, a lot of times they won't. And the best way to ensure that you will have communication is to, if you're the person, the patient, to make sure that you have decision makers who can show up at the hospital, whom you would trust to, have the information, speak to the doctors, and make informed decisions about your healthcare.
Yeah, that makes a lot of sense. So you would say as soon as someone turns 18,
absolutely,
they should really get these things in gear.
Yes, I have 3 sons. As soon as they all turned 18, we're leaving for college, we did these documents. Of course, I kind of cried through the healthcare power of attorney because my children would have to make their end of life decisions. And naturally, they designated me as their person. And that was a very emotional moment, more for me than for them. But
right,
yes.
They're invincible.
Right. And also because I was, God forbid, contemplating these horrible things. So which one never wants to think about when it relates to their loved one.
Right.
Which is another thing that people should keep in mind when it comes to the healthcare power of attorney. When you're considering the people whom you'd want to designate as a patient advocate, sometimes it makes sense to designate the person with medical background. Maybe they're a doctor or nurse, or they work in a hospital setting. It might not necessarily be the person that you are the closest with, because of the emotional nature of this role. It could be very, very difficult to carry out those decisions. So it's not always the person with whom you are the closest. It could be the person whom has the internal strength to carry out what you would want. And that's really the sole criteria is, are they able to listen to what your choices would be and do what you would want, not necessarily what they would want for you.
That's a really good point, because I could see where a lot of people would pick their mom, and then that's probably the most emotional.
Correct. And that's it. I have a colleague who always would say, my mom and I are the closest, but she's the last person I would ever ask to do this job, because there's no way that she would ever pull the plug on me. And this is something that I would want under certain circumstances.
That makes sense. Yeah. And it's like hard to make really good decisions when you're an emotional basket case, right?
That's right.
So what if someone's married and they have these forms with their spouse, and now they're contemplating divorce, or they're going through the divorce process? can you just get them changed? Do you need permission from the person that you designated? What would you do for that situation?
So here's what I would tell you. If you're contemplating divorce, and you're really, you think this is something you're absolutely going to pull the trigger on, you should get those changed before you file the complaint for divorce. The problem is you're not yet divorced. What if you reconcile? Well, then I say cross that bridge when you come to it. But I would strongly recommend that if someone is getting ready to file, that they consider making those changes. They do not have to consult with their spouse to make those changes. The challenge that they might have is if they go back to the attorney that did their original documents, that attorney might have an ethical quandary about representing that individual after he represented them as a couple. So I might not want to prepare documents because of the ethical issues associated with it, but you have every right to change your documents. Now, if you have already filed for divorce and you're going through those proceedings, in many cases, a restraining order gets entered, which is called a status quo order, which says no changes of any kind. Now, I haven't been in this situation where I've had a client come right after that order has been entered. I would say that that will typically govern financial matters. You can't like take money out of the bank or, go buy some lavish, make it a lavish expenditure. You can basically just pay for the things that you've been paying for all along. They don't want any dramatic movement of assets. That could also apply to estate planning documents. So if you have already begun that process, I would definitely want something. If that order was entered, I would want that to say something like, but people have the ability to, change powers of attorney. And I haven't been in that situation, so I'm not certain the language that would be on that order, but that's the one exception that I don't think anyone would take issue with. Because the last thing you'd want is for your future ex-spouse to be making the decision about whether to pull the plug on you.
Right. Or have the capacity to take money out of your account
well, for that's an easy one. But it does get tricky. You as an individual have the ability to make your own decisions. Does not have to be in concert with a spouse. And in fact, I've represented one person in a couple who is married because they have felt very strongly about wanting to just do the process on their own. Sometimes they may have a shaky marriage circumstance to begin with, but it's not typical, but it's also not unusual for me to represent one person who in an estate planning process and not the other.
Okay. That's good to know too. Yeah. Or sometimes people are like, oh, I don't want it. We don't need it. And then the other person says, yes, I want it and I need it.
Precisely. And it's not always the shaky marriage, although I've had, individuals come in and say, yeah, I don't know if this marriage is going to last. In which case, again, we go back to the ethical quandary of the lawyer. The lawyer, right. If they've just met with that person and they say that to them, they're only meeting with that person. It's not something where I would say, oh yeah, bring your spouse now. Because when I represent a couple, I explain to them that I have a duty to represent both of them and I can't keep secrets from either one of them. So
that makes sense.
Yeah. Yeah.
Everything gets a little bit tricky when you dig deep enough, doesn't it?
Yes. I mean, absolutely. But you have the right to do these things, whether you do it with your spouse or not. And you should have them done.
And if you don't have them and you're going through the divorce process, it's still not a bad time to get them.
No, in fact, if you don't have them, I would encourage a person to get them as long as the order doesn't provide an express prohibition, because I'm never going to advise someone to violate a court order.
Right.
So I want to make sure that's clear. But so that again, I would want to do that kind of in concert with the advice being given by the family law attorney.
That makes sense. Yeah, and
Yeah.
this always seems to be something that doesn't really get at, or at least it doesn't come up when I talk to people, which even though I'm talking to people about the mortgage and the real estate, we seem to talk about a lot of other things just because they come up, and no one really ever brings up estate planning. And I don't even typically bring it up until the end, you have a new home, or now you transferred the deed, are you updating? But yeah, the beginning part is important, and I don't really hear that very often.
Well, let me just say, first of all, I think that's very unusual for a person who specializes in mortgages to even address something like that. So I commend you for bringing that to the attention of your clients. That's I think very unusual. And any good family law attorney will also, in their closing letter, tell a client, this is what you need to do. Any of the family law attorneys that I work with always put a provision in there that addresses, making sure that you redo your documents. Now, one thing that I will say is, once you are divorced, the way that the law works is that anything that is revocable would be revoked by virtue of that judgment of divorce. Very often, though, the judgment itself or the settlement agreement will address documents and say anything that we've done is considered revoked. That being said, I would still tell clients you need to come in and redo things. And going back to that scenario in which you are going through a divorce and you have, and God forbid you passed away in the midst, that person, if they are your spouse and that judgment hasn't been entered, they are going to receive your assets.
Right.
So that's a pretty troubling thing for people who are going through divorce.
Right. And that does happen. It does happen.
Yeah, I've had that happen. And I've also represented a party who wanted to get divorced, and his wife, from whom he was divorcing, filed a petition. He was having early stage dementia, and she filed a petition to be appointed his conservator and guardian. And of course, I represented his son, and we objected and got his son appointed, because there's no greater conflict of interest than having the spouse from whom you are getting divorced basically being your voice in a decision regarding the disposition of assets which directly affect her.
Right. And of course, tricky.
Very tricky. So she had a very obvious conflict of interest, could not represent him. And of course, he very strongly objected to her representing him. And that was the reason he wanted to divorce her in the first place.
Craziness. That's crazy.
Yeah.
So people who want to get a hold of you, what is the best way for them to find you?
So the best way to find me, my office is in Birmingham. They can call my office at 248-530-1044. The name of my firm is called the Law Offices of Kristen R. Gross. So you could Google that. It comes up, pretty easily in Birmingham. And if they had questions, they can always email me. My email is Kristen, Kristen, at krglegal.com.
Wonderful. Well, thank you for your time. I so appreciate you going through this with me.
Thank you for having me.
I hope you enjoyed our podcast on divorce planning. I'm Carri Goldring, and I hope you have a great day.